Ladies and gentlemen, our members and guests connected with us this afternoon. This is our fourth day, a virtual marathon with the award, the patent of the year. In the first edition, the best patent to combat COVID-19 is going to be awarded to recognize the professionals that value intellectual property. The award has had the support of the Brazilian PTO, and there was a group dealing with the factors to the award: economic benefits, internationalization of protection, participation of Brazilian inventors, among others. Liane Lage has the floor. She is the patent director for the virtual delivery of the award. Can you turn on your mic, please? There you go. Thank you. Thank you, Erica. Thank you. I'd like to thank the ABPI. I'd like to say that I'm very happy to be here on behalf of ABPI to deliver this award. I am very proud for many reasons I will share with you. Also like to congratulate for the success of this event, because ABPI managed in the middle of a pandemic to organize one of the most important events in intellectual property. I was informed there were over 1,300 participants and 20% in the industry. And it's an incredible amount of foreigners, 240 people from abroad. So this is Brazil showing its potential in intellectual property for the world. This is, I'd like to make a reference to Ricardo Bluquin for his efforts. This is a very important award. This is a very important moment because in the middle of a pandemic, the first award, innovation award from ABPI, shows the world that our innovative potential was sleeping, and now we're ready to change this history. Other awards will come in the future. I'd like to thank the involvement of the Brazilian PTO, the support of the Brazilian PTO. Ricardo Rodrigues created a commission to judge the award by 3 professors: Adelaide Maria de Souza Nunes, Professor Alexandre Guimarães Vasconcelos, and Professor Yolanda Fierro, that assessed candidates by the elements mentioned by Erica: social benefits, environment impact, and potential for economic impact, 30% of the assessment, internationalization of the intellectual property, as well as Brazilian participants. This is very nice. And then finally, my joy in participating in an award given in the city of Rio de Janeiro. PI 0903-26665, title Method and Probe for Endobronchial Secretion Aspiration. And this goes to the Federal University of Minas Gerais: Márcio Quinotti Barbosa, Shirley Lima Campos, and Clayson Bruno Santos, and Danielle Neves Rocha, the inventors. I congratulate you and wish that this is just the beginning of an innovation path in your team. Congratulations, everyone. Congratulations to the Federal University of Minas Gerais. And this has been the delivery of this virtual award. This is a completely different world. Erica, where is the award? The representative of the Federal University is going to receive the award. We're going to give him the floor, and he's just in the process of connecting into this meeting. At this point, we're locating the professor. Can you please bear with us? We are just having a little bit of difficulty placing his image on the screen, but he's soon going to be here to receive the award. This is my first award to be delivered. Yes, there you go, finally. Professor Gilberto, you have the floor. I would like, on behalf of the Federal University of Minas Gerais, to receive this award. Professor Nachi is a mentor to all of us in the engineering school. He has inspired a number of generations of students to have an idea. He was a professor here. Unfortunately, he has passed away. But to give you an idea of the inspiration here among the students, two companies that were GE Healthcare has bought two companies started with our students. And one of the co-inventors, Professor Clayson, is also a colleague of ours. And this only stresses the focus we give on health applications. It's an honor to me to receive this award on behalf of the inventors, which is very close to our hearts here at the Federal University of Minas Gerais. Thank you so much for the invitation and the award. Yes. Today we are paying virtual tribute, but soon you are going to receive the plaque, the physical plaque at your university. Congratulations to you. And congratulations for having been awarded this fantastic award. We now move on to the plenary session, which is going to speak about intellectual property from an international perspective. The need to have an international system for recognizing intellectual property rights happens before a movement of integration of cultural and economic elements that we have been calling globalization, acceleration in transports and telecommunication, inserted us in a boundless market. So the need to create mechanisms to convert artists and entrepreneurs to the possibility of negotiating their work without having the risk of having their work appropriated by free riders. violation of rights of inventors, writers, authors, and so on is seen as an obstacle to disseminating industrial techniques and arts and technical knowledge. Exhibits such as the 1873 Vienna and led to the Convention of Paris in 1883 and Bern in 1886. And in 1893, BIRPI was created to manage them. Signatory countries extended to their citizens the same rights conferred to their citizens. Throughout the 20th century, intellectual property became the heart of the international agenda. Patents started to be also registered in other countries very quickly, harmonizing criteria to grant, and collaborations between national patent offices became a clear need to avoid delays in examination of trademarks and patents. In the 1940s, Belgium, France, Luxembourg, and the Netherlands created a community center for search of prior art for granting patents. Institut International de Privé was born in Paris. Other countries joined later. As the founders, the motivation of the new members was to avoid the need to create in each country large national offices with thousands of examiners, as well as facilitating the work of innovative companies and inventors. In the 1970s, two events were important to build a truly international intellectual property system. In 1970, received a mandate and was converted into the International Organization of Intellectual Property. So it had the BIRP members and other countries. This led to more harmonizing of laws for legal rules and procedures. And there was more cooperation between national offices. In 1973, the International Institute became the European Office of Patents, extending its membership. Advanced globalization and the GATT rounds led to the containment of high tariffs as an obstacle to commerce. The commerce of physical goods depends on protection of intangible goods associated to them. So they opened the debate on a global approach. The TRIPS agreement became a pillar of the World Trade Organization in 1995. During this period of time, there has been more efforts in harmonizing and simplifying procedures. Treaties were created in all fields of intellectual property and resulting in real collaboration between national and regional rights protections offices. This path goes on. To talk about the future, we will have the last plenary of the 40th International Congress of ABPI. Now I will give the floor to our president and moderator this afternoon, Professor Luis Edgardo Montauri Pimenta. Good afternoon, everyone. It's a great pleasure to be here closing the 40th Congress, ABPI Congress, with all of you. And before anything else, before I give the floor to our speakers this afternoon, I am going to read a summary starting with Megan Carpenter, She is the Dean of the University of New Hampshire School of Law, Franklin's Pierce.
Law at a law firm, Kilpatrick and Lockhart, now Kiel and Gates. Depois dela, ouviríamos o Dr. Antônio Campinos.
After her, we're going to have Professor Campinos, chairman of EPO. He was president in June 2008. Before that, he was executive director between 2010 and 2018. He has also been active in the PTO of Portugal. He was also chairman of the board of the Center of Studies of the University of Strasbourg on intellectual property. He has been awarded an award from the University of Alicante in Spain. And last but not least, we'll hear Professor Graça Aranha, Senior Director of ABPI. He is well known to all of us. He has a degree in law from the university. He also has a degree from the Hampshire School. He is a professor in law. He's a lawyer, regional director of the ABPI in Rio de Janeiro, Brazil. He has the pleasure of working on a beachfront of Copacabana Beach. It's a great privilege. So anyway, Dean Carpenter, you have the floor.
Change the screen and see if it's working. Okay, perfect. So as we close out the APBI Congress today, I'm reminded that this entire event has been such a testament to the importance of the digital transformation of our economies, of our lives, and especially right now during this global pandemic. Intellectual property has always been important. It's a framework for human creativity and innovation. But as we have undergone a digital transformation in commerce and socially and culturally, these questions really loom large. IP and innovation are at the center of many of the grand challenges that we face around the world. And having a global perspective on issues in IP can help us to turn those challenges into opportunities. So as lawyers, representing clients, and always as students of law, because it's changing all the time, we need to seek out opportunities that give us a global perspective. And we should be thoughtful about making sure that those opportunities are available to us and that we seek them out. So today I'm going to talk about two things. I'm going to talk about some of our grand challenges and the role that IP and innovation plays. And then I'll follow up with the kinds of educational experiences that we need to provide around the world so that we as lawyers are prepared to confront these challenges and to turn them into opportunities. You know, one of the things that strikes me, especially now, is that the intellectual property legal system is fraught with uncertainty, and yet it's at the center of some of the great important challenges we face around the world. As the legal framework surrounding human creativity in general, IP is relevant across industries and provides the foundation for innovation and invention. Transactions in IP that we work with all the time are the system of movement for innovation around the world. So I'll give you, this is an international kind of focused panel, so I want to give just a quick snapshot of the US, where nearly 1/3 of all industries are IP intensive. We estimate that IP comprises 38% of the gross domestic product in the United States, and that employment in areas related to IP are increasing at least as fast or often much faster than the national average. Salaries in IP-related fields are going up. We're seeing increases in numbers of STEM graduates, science, technology graduates. And the number of new businesses, startups in the tech space have been growing steadily over the last decade and is expected to grow even more in the coming years post-pandemic. Around the world, on a global scale, we're seeing the same kind of growth. Information and knowledge, IP, is the economic driver around the world. Employment opportunities related to IP are increasing. IP and technology, it's important to issues of global trade, and we see that, building bridges and falling apart, destroying bridges all the time. IP is essential to innovation for industrial economies, and really, as we think about social justice questions, access to justice, medicines, healthcare, public health in particular right now, those are really focused in IP and tech, and IPR is expanding when we think about adjacent areas, and I'll talk a lot about that here in a little bit, data and privacy in particular. So governments in countries that want to lead and want to recover in this period of time need to understand the role that IP plays. And who is important to that process? Lawyers. We all need to understand the interdisciplinary connections and components of IP. We're not really talking about individual food groups or separate areas anymore. The global pandemic currently makes apparent, and it has come up so many times in the last couple of days, as throughout these panels and discussions, the vital role that lawyers play in civil society, particularly in times of chaos and disruption. IP is at the center of all of that. Solutions to problems from, involving international peace and security are based in innovation. Data and privacy, fake news, critical in the digital age. Getting information accurately to the people who need it. And IP can help carve a path through this current pandemic, whether it's supporting vaccine development, on the front lines at the World Health Organization, developing learning technologies like we're using right now to all come together from so many different places, or helping to make public health policy. So I want to talk a little bit about some of the grand challenges that we face now. And I'm going to focus on global development, the increasing interdisciplinarity we're seeing as lawyers and the needs of our clients, data and privacy, and I think right now I'd be remiss if we didn't talk about public health a little bit. So first, let's turn to global development. The transition from kind of old economy resources to new economy innovation ecosystems impacts the international peace and security and relationships between and among countries, and also the ability for an economy to succeed, not just within the nation, but globally. So we're working around the world, and in some ways, I think country to country, we feel like we're doing it independently. But we're working across the world to transition from a commodity-based old economy resource to a new economy based on IP, information, content, knowledge. And that transition is critical. Developing countries are often dependent on old economy resources. And to be successful, we have to be making that transition, and they have to be supported in that transition. There is so much incredible human creativity that we should harness to create innovation ecosystems that are supported both nationally and on a global scale. When we think about mineral resources that the rapidly emerging global economy relies on, that allows it provides a great opportunity for growth through largely untapped markets, and there is an enormous emerging entrepreneurial sector. And this has come up a few times in the last couple of days, that the benefits of development partnerships and investment can be substantial. And the discussions that have happened here at APBI reflect this potential, that economic recovery can't resort to the ways of old, but we, as lawyers, can help bridge and help build a structure for innovation capacity. The partnerships in development can accelerate access to innovations in health, agriculture, communications, energy, all the foundation for stable economic advancement. And this involves universities, and I will return to this again and again. Supporting universities in developing tech transfer offices, entrepreneurial programs, global education for an understanding of how more advanced IP systems operate. Creating that innovation capacity in different countries around the world will accelerate the kind of appropriate needed innovations into the marketplace that will drive solutions that can be maintained. So public health is a great example of that. Building food security, fostering greater educational opportunities, importantly, advancing economic development and leveraging those knowledge resources. It can generate new markets and spur greater indigenous innovation as well. And that will help stable knowledge-based economies develop on a local and on a broader scale. That leads me to a second trend I'm seeing internationally that is an opportunity for us. What we need to do is increasingly think about IP as interdisciplinary. The issues of IP and innovation we have to be thinking as lawyers about the connections between not just individual areas of law. So when I started practicing, a couple decades ago, we thought of it as sort of, someone focused on patents, or someone focused on trademark or entertainment or copyright. But right now, and this is going to loop into the second part of what I want to talk to you about today a bit later as we focus on education. But one thing that I really noticed about the program for APBI this time has really highlighted the connections between and among IP adjacent fields. And I don't want that to go without being recognized and said, because I think that is the future. We used to think of IPR as kind of those food groups I was talking about, but increasingly, you're no longer sort of just a patent person exclusively. Increasingly, we see IP issues that are overlapping, interdisciplinary. We serve our clients best when we can recognize those connections and focus on the relatedness. Those challenges and opportunities lie within those intersections, and I expect that to increase. We've seen that through each day of this conference. And in the closing panel, I hope you'll indulge me a little as I'm thinking about kind of some of the topics that have been covered. You know, economic issues, when we think about the overlap in 5G technology, standardization, licensing, blockchain, discussions about industrial design for graphic interfaces. I've seen, you know, other forms of IP show up in what would typically be thought of as kind of a trademark panel focused on unfair competition or a patent panel. AI is a great example of all of this convergence, and mastering the convergence will be helpful to our clients. So, you know, the panel is focused on invention, but also involves copyright implications, the use of photographs to glean information to help inform the creation of the AI. Use of data from those photographs is another layer, how data and copyright intersect. So I look at it kind of like this diagram where it's a Venn diagram where everything overlaps on to each other. And to be the most successful lawyers in a digital transformation, we have to be thinking about those overlaps and connections. I also think that as part of those discussions, I hear from teams that seem to be most successful when they involve people from different perspectives. There's an article that I was reading the other day that was talking about how, you know, the research compiled by organizational scientists, psychologists, economists, show that diverse groups, people who bring different perspectives from different areas, are more innovative than groups that are homogenous. So I would say not only are we looking at interdisciplinary issues right now, but we benefit our clients, and I think we'll stand out the more that we can assemble teams of people that bring different perspectives together. That without that kind of diversity of background and thinking, innovation's harder to achieve and initiatives can stall. So I think it's worth just a side note about how really to comprise leading teams going forward. I'd like to also focus tangentially now, or no, sort of segue into data and privacy. A significant part of the conference that we've had and the key to digital transformation involve data and privacy. It is both a local issue and a global issue. Last year, I met with several of the world's largest tech companies in the US Silicon Valley, and then also in China and in Korea. And at each company, I asked, what emerging issues should we make sure to educate global attorneys, who are, many of whom are our students, and many of you who have been our students, about? And uniformly, they said, data. What's the biggest issue you're facing coming up? Data. What's coming down the pike that we should be sure to focus on? Data. What distinguishes job applicants and outside counsel from the rest of the pack? A facility with thinking about data. So in this digital transformation, you know, people knowingly and unknowingly produce huge amounts of data on a daily basis. And we're increasingly relying on digital systems to manage internal operations of our clients. Governments are using it to rely on delivering public services. Data is often the currency for companies, the business model, the revenue stream, to be leveraged in different ways. And people are transmitting sensitive financial, health, and other personal information through online platforms. So control over data is more valuable than ever and will be going forward. And so as lawyers in the 21st century, we have to help companies as they seek to leverage data and also to keep others from exploiting the vulnerabilities that may result. Over the next decade, technology is going to continue to evolve, and data security programs in both the public and the private sectors are going to face new vulnerabilities. We see this in the APB, the Congress we've had over the last few days. It's a national issue in Brazil and also a comparative issue and an international issue, right? So we're seeing legislation at different levels. So the data protection bill from last year in Brazil is a great example. The data protection bill that's working its way in India right now is another kind of transformative piece of legislation. And Europe really has led the way on much of this, but we're seeing different national components that I think will really impact some of our clients that operate on a global scale. The most recent fake news bill that was a topic of discussion here yesterday, information and misinformation is also a national and global currency. And certainly extends to a human rights issue as well, but certainly an economic one. And we need to be thinking about these things, not just with national approaches on an individualized basis, but also global frameworks so that we can draw on the experience of others, because these kinds of issues transcend borders. When we think about data protection and exclusivity, that also intersects with patent and trade secret and unfair competition in ways that many people aren't thinking about. And attorneys that know about data and are conversant in these issues, that's critical as we go forward. So I'll talk just for a minute about one other challenge that we're seeing right now, and that is in public health. The pandemic has been a great example of what one of my colleagues, Stan Kowalski, calls a system failure. That, as we think about vaccines, those COVID vaccines are isolated, that data is not sufficiently shared between countries, that research is nationalized, that we are not sort of seeing sufficient leadership on within some of the traditional areas where we've seen global leadership. And, within countries that are historically leaders. And Professor Kowalski reminds me that the coronavirus is not just a disease, but really a symptom of problems that we could see throughout the 21st century. There are, lots of people placing blame, but what we need to do is to think about ways that we can work together as attorneys to mobilize human capital around the world. Human capital that's stuck in low-end manufacturing, commodity-based economies, and this loops back to the global development piece. Really, we need networks of innovation ecosystems, globally connected, interconnected ecosystems of human capital and creativity to solve problems. That will enable us to tap into a coordinated response to problems that affect the whole world. And those extend to, not just public health, but food security, climate change, and enables us to have all hands on deck to rapidly address emerging issues as they come. And I think that we have the possibility to lead our clients in this direction so that we can build new alliances for progress. Now, one thing that is critical is education. And so I'm a little biased here because this is my area. But when we went to law school, before we got to this point, right, in our careers, you learn the nuts and bolts of law practice. And we think about, what we need to know in certain subject matter. But in the digital transformation, IP is always changing. Sometimes, if you're like me, you might think, oh, I wish I had studied something that didn't change. You learn it, you know it for life. But that would be incredibly boring. we're in an area that will change so much no matter when you started practicing. You will see through the arc of your career an incredible transformation of not just sort of digital transformation, but a transformation of the law in this space and the infrastructure that supports us. So, what we're doing together internationally can really provide a model. And I think there are ways education should respond. So I've outlined some of the challenges that exist, also opportunities. But I think education needs to change because we all should be involved in learning so that we can help work together to solve some of these problems. And it all relates in ways to some of those things I just identified. An expansive understanding of IP and tech-related work. Global educational partnerships. We should not have, we should stop thinking about, an education just in the US. We should be thinking about an education that is in the US, partnering with Brazil, partnering with India, partnering with Korea, with China. And those ties make us stronger. We need to involve conversations with industry to assess needs, to figure out what we should be doing and what's right around the corner so that you can add value to your clients and for your own professional development. We should be building global relationships, global networks, have experiential learning opportunities where people aren't just studying in books, but they're on the ground studying all the time. And we should all help one another because we're learning things as we go along. And so, our networks, alumni, leading practitioners should be involved in the classroom equally so that we are all both students and teachers. At UNH Franklin Pierce, I really pride myself on the role that we have taken in the intellectual property space. And I'll talk a little bit just as an example that you all might use as you go forward to talk about how we manifest some of the things that I'm talking about. So we've been ranked, in the top 10 for IP ever since the US has been ranking intellectual property programs. Over half of our faculty have IP expertise. We have the largest, actually the only IP library in the Western Hemisphere. We are currently really proud of some of the innovative work that we've done. And we have a lot of hands-on IP experience. So we've historically had the Intellectual Property Summer Institute, where we brought attorneys from all over the world to come and learn, in addition to some of our students here in the United States. And we relaunched it again last year when the pandemic had started, realizing that we could reach a global audience and we could help educate. We could have a global classroom with attorneys from all over the place, interacting with one another, bringing those diverse perspectives, building their networks, sharing clients, maybe eventually getting jobs with one another, while they're learning some of these interdisciplinary cutting-edge issues. We focused on patent licensing, the cloud, AI, cannabis, pharma, media law, and fake news, gaming, so many different areas. And we had professors who were teaching from all over the world and students from all over the world. And that really helps build value for the students, for the attorneys who are participating. We also have students who are in our programs are getting the hands-on expertise. So our International Technology Transfer Institute helps build those innovation ecosystems around the world that I've been talking about. Most recently, in years, we've been working with Armenia, Algeria, Sri Lanka, to help build those ecosystems to transform the economy from old economy to new economy. So you, as an attorney, if you want to help out with that project, then what you can do is to get on the ground and do something like you've never done before, but create something that will benefit you and your clients later on. We also have, of course, clinical work where students get to participate in kind of the US legal system as well, and to write and publish at the same time. So this provides a really good opportunity for lawyers to build their networks. And we have, through our graduate program offerings that many of you are probably already familiar with, a Master of Law, an LLM, or an MIP, or certificates for people to get if they're taking the equivalent of a semester's worth of classes and can't be gone from their firm for that long. We offer at the same time all of these options, both online and residentially, and you could do a combination if you want to just make that global classroom accessible to everyone. And all of that comes at the same time that we have kind of the excellent outcomes of, sort of a quality law school to help you as you go forward. And people have found that to be very successful. So the approach that I'm talking about that is, I believe, is key to solving some of the global challenges we face around the world is, has benefited the heads of IP at, Bayer, Samsung, Microsoft, Disney, WeWork, Pepsi, just across the board. These leaders not only are being educated with us, but also then returning to educate the next generation. And that enables us to provide the kinds of courses that we're able to, that do all the things I was talking about sort of giving that interdisciplinary sense, the global approach, and enable those classrooms with different people with diverse perspectives. I'll stop there. I feel like I've just been talking. I could talk for hours about this, and I know you're anxious to kind of wrap up. But I just wanted to really congratulate APBI on what an incredible program this that has been put together over the last few days, and to say what a testament it is, I think, to not just the present of IP, but the future of IP and digital transformation. I'm really excited to be a part of it. If there are ways that we can partner going forward, I would be happy to do that. Thank you for inviting me. I'm so grateful.
Thank you very much, Megan. It was a very nice presentation. And I'm sure that besides Graça Aranha, our next speaker, and Fernanda Magalhães, who invited you, and you know her, we have a large number of our audience that attended Franklin Pierce Law School. I'm very happy to see also, as you mentioned, that this ABPI Congress discussed most, if not all, of the topics you brought in your presentation. So, blockchain, AI, sports, biotech, privacy and data. So we are happy that our goals were matched. So before passing the next speaker, I will just would like to announce that after Graça Aranha, the third speaker, I will be making the final announcements of the numbers of our Congress and some details of the participants. So please, now the presentation for Mr. Campinos.
Uma muito boa tarde a todos desde Munique. Lamento não poder
to all of you from Munich. I'm very sorry I can't be there in person, but I'd like to send this message to my colleagues at ABPI.
say a few words to conclude this conference, where you've been discussing digital transformation, and to offer a few thoughts on the international aspects of IP, such as cooperation. I am a strong believer that cooperation begins with solidarity, with understanding. So before we go any further, let me just say that the thoughts of everyone here at EPO are with our Brazilian friends and colleagues in these difficult times. People in South America, who are in Europe, and all over the world are, of course, all facing multiple challenges at the moment, whether on a personal or professional level. And like so many of you, I also think that shared problems are best solved with joint solutions. That's a belief very close to my heart. And I'm privileged to spend my days in an institution where that ethos is part of its history. The European Patent Office, after all, is an organization itself born at a time when our predecessors chose to put their faith in multilateralism rather than unilateralism, with the aim of creating an harmonized European patent system capable of supporting a prosperous and peaceful Europe. And we see the effects of that approach today. Just last year, the EPO published a joint report with the UIPO on how much industries that use IPR intensively contribute to the EU's economy. And the results are quite something. IPR-intensive industries contribute 45% of the EU's GDP, or 6.6 trillion euros. Those same industries also indirectly and directly generate nearly 84 million jobs, or almost 39% of our European workforce, and pay higher wages. So IP gives us real economic power. But there is even more good news. In times of economic uncertainty, companies that use IPR intensively are more resilient. They weather storms better and bounce back quickly. Statistics that we analyzed from 2011-2013 show that even during severe financial crisis and recession in much of Europe, IPR-intensive industries coped better with the difficult conditions than the rest of the economy. And it's those industries that will help us to pull through the economic aftermath of COVID-19. So it's great to see that innovation is vibrant in Brazil too, and that it's having a highly positive impact on the economy. According to the 2020 Global Innovation Index, Brazil ranked 4th among the 18 economies in Latin America and the Caribbean, with particularly high scores in human capital and research, business sophistication, and knowledge and technology outputs. And I'd like to add that we are also impressed by Brazil's draft national strategy for IP and its ambitious visions for the country's future role in the global IP system. Because innovation makes our society smarter. It makes us more sustainable, and more importantly, it can help us tackle the great challenges of our times, such as this pandemic. It's innovation that's developing potential vaccines, life-saving medical equipment, and the other technologies that are managing the effects of the virus, such as smart tracking systems. So we know what IP can do. It's societal benefits, economic benefits, and we know that we need those now more than ever. But we also know that if we want to keep benefiting from IP, there are two major points that we simply have to keep pushing on the agenda: international cooperation and digital transformation, the last of which has been discussed widely at this conference. But both of which are essential, because together they make us more effective as IP offices, as IP practitioners, and as an international community of IP professionals. And on the topic of effectiveness, I would like to take this opportunity to commend INPI's effort in tackling and significantly reducing its backlog over the past 14 months. This will not only promote innovation in Brazil, it will also make the country more attractive to foreign investors as they benefit from a more timely patent granting process. By working with partner offices, we are aiming to ensure that they can reuse our work products, generating efficiency savings and supporting efforts to bring top quality patents to fast developing economies all over the world. And more countries are recognizing the benefits of this approach. In fact, an agreement signed with ARIPO last December took the total number of inhabitants covered by the EPO's work up to around 1.9 billion inhabitants across 60 countries. In Latin America alone, the EPO has signed reinforced partnership agreements with Argentina, Mexico, and more recently, of course, with Brazil back in November 2019. These agreements aim to further integrate the global patent system by helping our partner offices increase their capacity, productivity, and quality by using the EPO's work products, tools, and practices whenever possible, while respecting national IP laws, of course. And all of those countries I mentioned, as well as Colombia, use a cooperative patent classification system, leading to even greater accuracy in classification. Just last November, we also signed a landmark agreement with the China National Intellectual Property Administration, CNIPA. Our agreement means that Chinese applicants filing in English with CNIPA as their receiving office can select the EPO as their international searching authority. This 2-year pilot scheme will make the EPO the first patent office outside of China to be designated as ISA for Chinese applicants. That's something of a landmark and, I dare to say, an endorsement of the quality of the EPO's work and a strong show of faith in the European patent system. Such cooperation would be impossible to expand and improve without digital transformation. In fact, at EPO over the last year, we've seen how it would even have been impossible to keep going without it. Because by March this year, 90% of our 7,000 staff started teleworking from home, and today that figure still remains at around 80%. So we had to accelerate our digital transformation. And I think that the fact we'd already started that process put us in a far stronger position to respond when the pandemic came. Our IT department, for example, was already restructured to make it leaner. Our decision-making process was faster, and we had already started investing in upskilling our staff. In practice, this also put us in a position to roll out new digital workflows for search and examination, as well as new digital annotation tools in March and April. And we also took a big step closer to a web-based workflow for files with the launch of our new patent workbench at the beginning of August. That was a major milestone for helping our examiners and formality officers work digitally. And at the end of September, Patent Workbench became the main platform covering the most important actions and interactions between examiners and formality officers in the patent granting process. Digital transformation has also helped us to protect the legal right of applicants to be heard in the patent granting process. The use of video conferencing by default for oral proceedings in examination was introduced on the 1st April 2020. To date, we have conducted over 1,200 oral proceedings this way. And now we are currently running a pilot on oral proceedings in opposition by VICO, together with a trial of the Zoom platform. But of course, when it comes to digital transformation, the game changer we are all facing is AI. And here, there are two considerations we really have to debate and discuss as an ABPI community. First, how we deal with applications that involve AI, so the patentability issues, questions such as inventorship. Some of you might know that in January we had a legal case on this issue when a machine called Dabus was named as the inventor. The EPO rejected both cases, and now appeals are pending before the Board of Appeal. Overall, though, I think the European patent system in its current form is able to deal with the legal issues arising from AI, especially combined with a transparent, predictable, and well-established practice in treating computer-implemented inventions. That said, we do want to keep discussing this issue with our stakeholders and our international partners. At the moment, we are promoting exchanges with users, WIPO, and the other big IP offices on AI and patentability. In January this year, for example, we hosted the ABPI's first joint task force meeting on new emerging technologies. And in November, we will be discussing AI-related issues like inventorship and clarity with our member states at the next meeting of our Committee on Patent Law. The second issue we are addressing at EPO is how we are using AI as an office. We have been actually using artificial neural network technology in our patent translate tool since 2017. And for pre-classification, we're already using AI in order to automatically pre-classify incoming patent applications and to perform automatic searches on incoming patent applications. But in the future, we're exploring and boost efficiency in other parts of the patent granting process. For example, helping to route the right file not only to a technical team, but to the right examiner, which means allocating the file to the most qualified and competent staff member. Our new end-to-end digital PGP platform will also feature an AI-based search function that includes recommendations for examiners. But at the end of the day, the final judgment will always fall to our expert examiners. Artificial intelligence will only be supporting them. And that's an important point. Our examiners have the final word. Because our AI-based tools will adopt an explainable AI approach that allows examiners to follow or to reject the AI's reasoning. The last word will still be the human's examiners. And as my last word, I simply want to say that this conference helps us to keep talking, keep debating, and keep finding ways forward to address the topical issues of our time, whether it's digital transformation or any other big issues. Especially at a time like this, when the world landscape is changing. That's certainly given us cause to reflect and assess how we can continue to be effective in a new normal environment. So in a few months, when we publish a strategy for operating in the new normal. And I certainly hope you will give us your valuable feedback so we can build a stronger, more effective IP system that we're proud to pass on to the future generations. Stay healthy and stay safe.
Muito obrigado, Dr. Campinos, pelas suas palavras aí. Eu estou vendo que
Thank
nós...
you.
Thank you
Professor.
so much. I see there are topics are very
Sua última menção
timely. In your last mention, in terms of discussing such topics in congresses and webinars is crucial for all of us and also for the industry or for universities that have also taken place in this debate. This debate is necessary, important in Brazil and worldwide.
And spread all over the world. Campinos mentioned the issue, the discussion, and the national strategy for intellectual property. I'm sure that Graçaranha is going to comment on this. The backlog of patents in Brazil that is being solved, as well as artificial intelligence, a discussion that happens all over the world. This was also touched upon here. We mentioned the very well-known case Dabus that is under appeal, still not pending a final decision. But before I give the floor to Graçaranha, I would like to make a special thanks to the organizing committee and everyone that helped us intensely, with also our audience. And now I give the floor to Professor Graçaranha for his presentation.
Muito obrigado.
Thank you, dear Chairman Luiz Edgar Montauri.
Megan Carpenter, caro presidente Antônio Campinos, prezados,
President Campinos, dear friends of ABPI, on behalf of WIPO, as well as Dan Tank, Director General, it's a great honor to be part of this closing ceremony of the 40th Annual Congress of ABPI. As
today, Franklin Pierce School of Law, University of New Hampshire. It is an honor to share this panel with Dean Carpenter. Now I can say I have met every dean the law school has had since its establishment in the 1980s. Eu fico também muito feliz em dividir esse painel com os amigos de longa...
It's a great pleasure also to share this panel with old friends Montauri and Campinos. This panel has a very broad topic: intellectual property, international perspective, and its role in digital transformation. Since the first law regulating this topic in 1474 in the Republic of Venice for the protection of the glassworks in that region. So that was the first law, patent law, and a long way has been threaded since then. Throughout time, this topic of intellectual property has been updated and adapted to advances and technological progress in 500 years. And this has been intensified rapidly with more advances in technology, with digital transformation and artificial intelligence. And this is just going to accelerate. I'd like to congratulate ABPI for this interesting brief video of the 500 years of history of intellectual property. This is a very important document for ABPI to make available to its partners and members so that they can use it well. Obviously, always mentioning the source. The world is going through deep changes, and the pandemic that has taken and still takes so many lives has accelerated transformations. The positive side, if we may mention anything positive related to the pandemic, is that the pandemic has really intensified international cooperation in many ways. A concrete example is the search for a vaccine that may mitigate and solve the damage caused, the harm caused by COVID-19, the virus, coronavirus. So the fight to find a vaccine has a lot to do with intellectual property. And in fact, it is based on industrial property. Thanks to the patent system, we hope that sooner than later, one or more than one vaccines will be available in the market. So this has been the best example, the current example of international cooperation, of the power of multilateralism, as Campinos has mentioned, the role of international organizations looking after intellectual property, the role of the United Nations and its specialized agencies. On the other hand, it is shocking to realize that in the power instances of some countries, people that believe that the earth is flat, people that question multilateralism and international cooperation, and who also question intellectual property on personally, it's important to say that this is my personal opinion. It is shocking to see that people question international cooperation and that consider it as a globalization to be fought against, globalism to be fought. This confusion without knowing who globalism is and who the enemies are. The enemies of humanity go against common sense. This thinking cannot be further away from reality. digital transformation and intellectual property ecosystems will get rid of this thinking that has nothing to do with reality. The accelerated development of technology will shorten the way towards artificial intelligence, also mentioned by Dean Carpenter and Campinos. Artificial intelligence is going to be increasingly present in our lives. Everything is going to be transformed, from interpersonal relations, labor relations, governance, the way government works, production chains, and the way people actually entertain themselves, leisure activities, and what is going to be the legal rules that are going to standardize transformation. It is our intellectual property. It's going to be at the heart of this new threshold that we're about to reach. We are just in the beginning of artificial intelligence. Everything's going to change. The national administrations, the patent offices all over the world will change entirely. Today, I have cooperation mechanisms that have been developed and that were developed in the last century, rejected by a smaller number of people. Fortunately, the collaboration between patent offices, the lack of cooperation leads to rework, and it turns us into silos, islands, and this framework has to be changed. I take this opportunity to, again, this is my personal opinion, and this is a result of my experience in this topic and my law education from Dean Carpenter's Law School, to mention the discussion that is completely outdated about lifting the sole paragraph of Article 40 of the Brazilian law. The people who advocate the change, and I believe they are not many, they are not serving the country at all in the short term. If they manage this, if implemented, this change will lead to yet another obstacle to legal stability and legal security in Brazil. This was emphasized by the President Martins in the from the Superior Court of Justice in the opening session of this Congress. It is essential for both national businessmen as well as foreign businessmen invest in Brazil, and as a result, pay taxes, create jobs and innovation in Brazil. So this change, suppressing this article, is something that has to be shown. Many people are participating in a debate that is purely ideological. Looking at numbers, figures that were calculating potential losses that would be a result of the implementation of this paragraph 1. If we take 10 studies from 10 different institutions, we're going to see completely different numbers, some showing losses, as this was the case, and another one showing incredible profit. So, because this is what keeps the patent system still kindled. in Brazil. Suppressing this article would send a terrible sign to investors in general. And before thinking of suppressing the sole paragraph, the Brazilian PTO should be granting patents in a reasonable amount of time. By the way, a reasonable amount of time is an obligation of the TRIPS agreement from the World Trade Organization, and that have been ignored by us and also ignored by our commercial or trade partners, that if they were if they paid attention to this, they would have sued us. You know, the World Trade Organization has teeth, it bites. So nowhere in the world takes such a long time to grant a patent. The 15 years that Brazil used to take, and now the 8 years currently, after a major effort that have been implemented for the last administrations, Professor Pimentel at the Brazilian PTO, and more intensely for Professor Claudio Furtado, this delay of 12 to 15 years has been reduced, and we managed to get it down to 8 years. With the support of the current Minister of the Economy, the Minister of the Economy, the examiners have managed to reduce from 15 to 8 years. So it is unreasonable. There is no explanation. It makes no sense that this sole paragraph should be lifted when we still wait 8 years for concession of a patent. Any change in the ministry, any change in the management of the Brazilian PTO would lead this to go back into that long backlog. That paragraph should only be removed when Brazil starts to grant patents like all other countries do. I repeat, all other countries take 2-3 years, 9 months to grant a patent. And when that's the case, when the Brazilian PTO grants patents quickly, then this sole paragraph is going to have no effect. And just to wrap up, I'd like to take the opportunity to mention an event that the WIPO and the ABPI are organizing on the 27th, WIPO Green Acceleration Project. It's a webinar to disseminate the project that the WIPO has conducted, developing here in this region with the governments from Argentina, Brazil, and Chile to facilitate the exchange and licensing of green technologies in specific areas of interest for each country. This is yet another example of an international cooperation of great success in the intellectual property. President Montauri asked me to mention briefly the national strategy that has been developed here in Brazil under the initiative of the Ministry of the Economy, to be praised. A number of countries have done it. A number of countries still do it. Developing countries such as Brazil, industrialized countries such as Japan, Israel, other countries, Peru, Chile, so many others, Cambodia, Vietnam. It used to be just like us in Vietnam over 10 years. Today, things are much better in Vietnam. So this national strategy is very relevant. We have to discuss it now. However, we have to follow the example of those who have been successful and not follow the examples that Brazil has been giving in the last few years, leading things to the state where we are today. Until 3-4 years ago, it took us 15 years to grant a patent. So that is implementing intellectual property in an ideological way, in a very superficial way. Dean Carpenter mentioned so many times the importance of lawyers studying this topic. And when this topic is discussed and thought between other sectors, they're not taking into account a number of aspects that need to be examined very carefully. This is a great opportunity that Brazil has now to get rid of this bureaucratic garbage, debris that has been created and has accumulated along the last 40 to 50 years with ideology, thinking that patent is not a way of innovation. In fact, a patent is an obstacle to innovation. This is crazy. It is a wrong approach. It's simply outrageous. There's no such outrageous thing anywhere else. So are we going to follow the right examples, the good examples? South Korea, Japan, Israel, Sweden, Chile, starting now, China, 40 years ago, did not have intellectual property. They had nothing. We have a system, a patent system since 1809. We were number 5 in adopting a patent legislation. And look at where we are. And when we compare to South Korea, a rural country, as somebody mentioned a few minutes ago in the other panel, until the 1960s, they were an agricultural country. From then on, we have to protect innovation. We have to be innovative. In the 1980s, South Korea invested the same amount, the same percentage of the GDP as we invest in research and development during the Sarney administration, second half of the 1980s. Minister Renato Asher, as well as Luiz Henrique da Silveira, were fighting within the administration so that Brazil would invest more in research and development. They managed at that time. We were following South Korea, and then this was abandoned. Today, we only invest 1%. South Korea, 3%. Today, they are at the front of technology. India, very similar to us, with such a huge population. 6 times our population invests in research and development. They have great results with this patent system. They don't believe the patent is an obstacle to innovation. It's the opposite. That is, patents foster innovation. So our national strategy has to take into account this idea. I'd like to thank everyone for their time and attention, and repeating the last words of Antonio Campino: stay safe, take care of yourself. We're still undergoing a pandemic. Stay safe, everyone. Thank you. Thank you, Professor Graçaranha, for your relevant remarks. As to this point you have emphasized, rightly emphasized, regarding the sole paragraph of Article 40, I would like to stress here again that once this topic started to take repercussions, ABPI immediately, when the media started to mention it, immediately positioned itself by publicizing a manifesto, a whole page on one of the most important newspapers in Brazil, with ABPI's position on the topic. As you said, it's a very important topic, and Brazil, in one of the table topics, and Graçaranha mentioned, and I thought he was going to repeat it. I am going to repeat on his behalf. He mentioned some figures. At the end of the day, we actually know, but because we don't mention it regularly, when he said it, I was scared. China today has 2 million patent applications, US 500,000, Brazil 30,000, 30,000. The gap is huge, in fact, and the objective is that we need to strengthen our intellectual property system. ABPI is always going to seek the perfect operation of the intellectual property system in Brazil and attract more patents to this country. Having said that, before I give the floor, before I mention the last figures, because I wanted to talk about our large audience, I'd like to ask if our audience, anybody has a comment or a question from the audience. And then I will mention the figures we have collected. Anybody wants to make a comment? Gabriel Leonardos, Chairman. Graçaranha is asking for the floor, but afterwards I'd like to say a few words. You have the floor, Graçaranha. Well, thank you, Gabriel, Luiz Edgar. Just to add to your figures that you just mentioned, well, China has 2 million applications for 40 years. They protect the patents. They have 2 million. Since 1793, US protects their patents. They have 500,000 applications for patents, and not us, 1809, a little after the US. Now it's 30,000 in Brazil. 10 years ago, there were more than 30,000. The patent system, the way it's been dealt with in the last decade,
this system was made weaker in Brazil. But we have to think that in addition to these that I mentioned, some come through the city. In terms of what we receive in Brazil, most are utility models. Invention patents here in Brazil account for a very small number. Therefore, this unwillingness vis-a-vis intellectual property, the time it takes, is it helping innovation here? If the number has decreased, it is very low. No, of course not. So the response is very clear. Are we going to follow the successful examples that I mentioned, or remain in the same track that brought us here? Thank you, Graçaranha. Dr. Gabriel, you have the floor. As we can see, ABPI has never been so close to WIPO as today. What Dr. Graçaranha said could have been said by anyone from any of the directors of ABPI. I'd like to use this opportunity to, on my behalf and on behalf of all the directors, all associates, congratulate you for this brilliant event that is that we are concluding now. I would like to greet and congratulate Erica, who work for this success together with many cooperators. We are very proud of this Congress, and like I said, that we've always been working in a very friendly environment. But now that we are necessarily working from remote areas, I think I miss you even more, all those who work with me at ABPI. And I hope that next year, after the vaccine, we can all be together again. Thank you, Gabriel. I make a point of extending your words of thanks to all participants, to the speakers, to our audience, to the sponsors, and to the organizing committee who they are all here, in special Dr. Felipe and Dr. José Eduardo, who have actively participated in this long preparation period. And as Gabriel Leonardo's already said, congratulations and thank you, Erica, and your team. It was a joint work. Certainly, there was a lot to be done. We incurred in some mistakes. I believe that the mistakes were mainly in terms of the technology, but we tried to do our best. But I believe, given the comments that I've received so far, these mistakes were not very relevant if we compare them to the incredible compliments that we received. And the criticism that we've received, it was always constructive. It was always in the sense of cooperating and learning from this fast remote Congress. And I don't know if you've been in that situation, but it's very difficult to organize a large virtual event for the first time. And let me remind you that we are in Brazil. If we were in Switzerland, that's where Dr. Gassaraia lived for many years. Maybe there it would be easier, but here in Brazil, it's a hard task. So I'd like to open the floor if anyone would like to say anything else. If not, I will go on, and I would like to give you the numbers that we have so far. Our figures are, we had 1,223 people that registered for the Congress from over 30 different countries. And I would like to highlight the countries that had the largest number of attendees. Maybe this is new to us. Of course, this is also due to the fact that we had a virtual event. But we see that there is an interest in many countries. And let me read you some of the names. Portugal, US, Argentina, Uruguay, UK, Venezuela, Canada, Mexico, Taiwan. And let me stress Taiwan. We had a very significant participation. Switzerland, China, Dominican Republic, Italy, Spain, India, and Dr. Gassaraia mentioned India, France, Chile, and Sweden. So we had a global audience, extremely relevant for a seminar organized by a Brazilian Association of Intellectual Property. The average number of participants in our plenary sessions was 900 people. 900 people. It is quite impressive. The average number of people in the panels was 600 people. And an overall 107 lectures. This was the total number of lectures, and a large number, and with the participation of foreign speakers. 24 foreign speakers who participated, and of course the fact that it was virtual made it easier. The table topics, which were very successful based on what I've heard so far, in which we could have more in-depth discussions on some topics. And these topics had been selected precisely by those who were leading the organization of the table topics. Also, the emphasis was in an interactive system with questions and answers. So this format, this choice was very fortunate. I believe that based on the comments that I heard, this was very successful. And to conclude, next year, we hope to go back to our traditional date of having our Congress in August. And we do hope that we can have an in-person Congress. If not possible at all, we do hope that it will be a hybrid process, half remote, half in presence, but I know that there's still a lot to happen before then. And my wishes certainly are that we see an improvement in the current situation. Now, the award that was given this year, our idea is to have it next year to another segment, another area in the market. I believe these were my final comments. Erica will say a few additional words so that we can conclude our conference, the 40th ABPI Congress. Thank you so much for your participation and stay healthy, all of you. Thank you, Mr. President. Thank you, all of you, for your support during these 4 days and actually during the whole period during which we were organizing. So thank you for trusting us and for believing in our initiative. The additional information that I would like to convey to you is that all videos will be in our platform so that all attendees will be able to access in the following days, months. We don't know exactly how long, but it will be in the platform so that this content can be assessed. We had 28, 30 sessions in 4 days. I'm sure it's impossible to benefit from all of them. So that's why they will be made available so that you can watch them anytime that you want. I hope to see you all in our next Congress, virtual or we hope in presence very soon. Thank you and see you next time.